Okay, order was passed on last Monday for the personal appearance of the respondent, your lordship.
Yeah.
Letter listed.
Oh. Okay, you given a memo on,
It's set for tomorrow.
huh? Tomorrow. Okay. Put it on Wednesday. Wednesday. Wednesday.
With consent of others, and item number 16, madam, some difficulty to them. Can it be next week?
Item number?
16, one.
Okay. On the prayer of Mr. N.J. Das, learning the mic as for the appeal. The appeal stands adjourned. The hearing of the appeal stands adjourned for hearing. As it is submitted that consent has been taken from the learned council for the respondents to make the prayer.
Deputy.
This for episode. Item number 1.
Still appeal against conviction. So perhaps notice will have to go to the informant, your lordship. Because though the conviction is under 376, proceedings arise out of.
You are,
I'm appearing as a legal aid counsel.
okay. Heard Mr. K.P. Pathak. Someone else's name is showing.
Lordship, there was a mistake in the cause list. My colleague's name was shown. I'm appearing as a legal.
And Ms. Sage Bora, learned additional public prosecutor for the respondent number 1, State of Assam. I think notice should go to the respondent here. This criminal appeal is preferred. It is criminal appeal under 4152. BNSS is prepared against a judgment. An order dated 22/01/2025. Passed by the Court of Learned Special Judge Poxo Kinsukia in Poxo case number 70 of 2022, arising out of Soikhuaghat Police Station case number 57 of 2021. By the judgment in order dated 22/01/2025, the accused appellant has been convicted.
And 376 2A.
Has been convicted under section 376 within bracket 2 within bracket small f of the Indian Penal Code, and he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, in default of payment fine. 10,000, no default sentence perhaps. So we have gone through the contents of the order of appeal. First of the criminal appeal is admitted for hearing. The records of case records of case number so and so be called for. Issue notice returnable in 4 weeks. As Ms. Bora has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of foreign notice to the respondent number 1 is dispensed with. First of the appellant shall take steps for service of notice upon the respondent number 2. There's informant in terms of the practice direction. Write down insurance.
I was also going to the notification. Though the conviction is under 376 2F, the notification says cases arising out of POXO. So perhaps the conviction need not be under the POXO. Even if it arises out of a POXO case and the conviction is under a different provision,
Right.
even then, yes.
No, IPC on some of them.
If your lordship has the clause C, your lordship, of the notification.
Get 2F. Our notification on some. What is the finding regarding section 4?
The finding regarding section 4, your lordship, that was not established. That your lordship will have at paragraph 53 of the judgment. It's at page number 72.
Pokso no harm kuch. Pokso no harm. The appellant shall take steps for service of notice upon the respondent number 2 by registered post within 3 working days from today. This is the case after courts.
Lordship, my name may be reflected in
The name of Mr. K.P. Pathak, Land America Security, is to be reflected in the cause list.
Item numbers 2 and 3.
It will go by.
The finance or virus of the rule has been put to challenge. There is a long checkered history actually. We are this petition, instant petitioners have appeared in the departmental promotion examinations. And those candidates who have failed in the examination, they come up and challenge the entire selection process on the plea that more than the instant petitioners who are sought to be promoted to that post are more than the numbers which has been advertised.
You are the failed candidate.
No, we are the past candidates. Your Lordship. The issue is like this, Your Lordship. The issue revolves around the promotion to the cadre of audit officers from the cadre of assistant audit officers. Now there is a departmental promotion examinations which has been conducted, and one has to secure a minimum pass mark of 40 in each papers, and in aggregate one has to secure 45. So admittedly, these all petitioners have passed the departmental promotion examinations. Now, there were some 11 to 12 candidates who had failed in the examinations. Rather, I would say that they got an exemption. Now, exemption is something you like when someone scores 50 marks in one of the papers, he did not appear in that paper out of the 8 papers, but if he has failed in the rest of the papers, he have to appear in these papers. So they come up and challenge and say that these persons could not have been promoted to that post, although we have cleared the departmental promotion examination. Because initially the advertisement was for 32 posts. So that was their plea. Now, during the pendency of the case, the secretary of the finance department, they came up with an affidavit saying that because of the lapse of more than 12 months, the validity of the select list has gone. Now, therefore, in that view of the matter, we could not be appointed. Now, what we have stated in that case is that this is not unlike any other regular promotion. Here is a promotion where one has to clear the departmental promotion examinations, and then only that can be appointed. So in that view of the matter, we have put to challenge the virus of the rules 20 subclause 3. So that has been put to challenge. Now, thereafter, during the pendency of this instant writ petition, we have filed an IA saying that there are 2 petitions. Actually, one petition we have filed saying that the other petitions we have filed saying that the examinations are being conducted. Those posts are meant for us. So we have challenged the virus also saying that, and during the pendency of this case, we have filed an IA 1474 saying that the examinations will be held on 17th to 20th June. Our post will be there. So your lordship may at least secure our post. So on the last date, the court directed specifically the finance department to file an affidavit so that the hearing can be undertaken.
Come to the judgment whereby the repetitions, two repetitions were disposed of.
Yes, your lordship,
Ah.
but the result should not be declared, your lordship. Yes,
Paragraph 12,
yes, your lordship. We've stated.
after quoting Rule 23 in paragraph 11 of the judgment.
Yes, your lordship.
And court has recorded its finding,
Yes, your lordship.
paragraph 12. No room for doubt on expiry of 12 months.
Yes, your lordship.
From the date of approval of the same by the APSC, the list of departmental candidate would lose its validity. Available regardless whether the so and so no further promotion could have been made by the authorities based on the list dated so and so after the so and so. There is no doubt in this case that the period of 12 months has expired long back. There is also no judicial order of the court extending the validity. That be so. It is apparent that as long as 23 continues to hold the field, no promotion of the will be made by operating the the petition. Will you still the validity? What is that advertisement? 16/9/2024.
Page 191. Your lordship will kindly take up WPC 926. None?
It is what prayer you are seeking.
My lord, we are saying that the examination itself should be kept in abeyance. The reason is, my lord, this.
There is a categorical finding also in the paragraph 12, 13 and 14 in the judgment. How do you reconcile that?
My lord, that is what is under challenge. If your lordship kindly just has a look at the rules, there is a apparent fallacy in the rules. If your lordship will kindly come to the rules, sir. Page 49. If your lordship kindly turns to page 30, your lordship will find that the cadres,
Which read petition?
926,
Page?
page 49, the rules are annexed. If your lordship kindly turns to page 50, your lordship will find that there are 4 different cadres: deputy director, assistant director, audit officer, and assistant auditor. Now, if your lordship will kindly turn to part 2, which your lordship will find at page 58. For deputy director and assistant director, it is a normal procedure of promotion, rule 13 at page 58. If your lordship kindly comes to rule 15, your lordship will find this is a normal promotion. As in all other cases, there has to be, sub-rule 3 will show that there has to be a double the probable number of vacancies that has to be notified, etc. If your lordship will kindly come to part 3, this is what we are concerned with. This is a promotion through departmental examination at page 60. Now, if your lordship kindly comes to, this is rule 17, sub-rule 3 at page 61. The Assam Local Fund Audit Service promotion examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such intervals as the appointing authority may, in consultation with the Commission from time to time, determine. A list of candidates who have qualified in the said examination shall be prepared by the Commission in order of merit and forwarded to the appointing authority. Promotion shall be made from the list subject to availability of vacancies. So the whole idea here, the people who pass the examination, as and when vacancies arise, they will be appointed against those vacancies. Now, if your lordship will kindly come to, the problem gets created here. Then there is rule 18, if your lordship will kindly see rule 18 for a moment. So this is for 75% of the vacancies are required to be filled up by departmental examination, and rule 18, the remaining 25% are done by direct recruitment. Now, if your lordship will kindly come to rule 20, sub-rule 3, this is what is under challenge. The list of departmental candidates for promotion of the cadre of audit officer under sub-rule 3 of rule 17 shall remain valid for 12 months from the date of approval of the commission. Now, if this list remains valid for 12 months, 2 things happen, Madam. Firstly, people who pass, because under the same rules, once you pass, you cannot sit in the examination again. So if this thing remains valid for only 12 months, these people will again have to sit in the examination. And the other problem is, for the direct recruitment, your lordship will find that the list will remain valid for all times to come. Direct recruitment is rule 18, and there is no similar provision that the list will be valid for 12 months. So this ought to have been, this is apparently a mistake.
Right, Mr. Chaudhary, come to the judgment.
My lord.
Where 3 petitions were considered and 1 petition kept.
My lord.
For, I don't know, for how can the single judge forward it to the division bench?
My lord.
That I don't know.
That, my lord.
That procedure I don't know. But so far 1123 is quoted.
My lord.
Now see the observation in paragraph 12.
However, my lord, this is qualified. If your lordship will para 15, my lord, if your lordship comes to para 15.
No, but categorical finding is there.
Observation is there, my lord, but
Huh?
paragraph 15 leaves it makes
No,
it.
let us read.
One.
Paragraph 12.
A plain reading of 23 leaves no room for doubt that on expiry of 12 months from the date of approval of the same by the APSC, the list of departmental candidates would lose its validity. As such, regardless of whether vacancies are available or not, no further promotion appointment could have been made by the authorities based on the list dated 7/11/2019 after the period of 12 months from its approval by the APSC. There is no doubt in this case that the period of 12 months from the date of approval of the list by the APSC has expired long back. There is also no judicial order of the court extending the validity of the select list. If that be so, it is apparent that as long as, this is the portion, it is apparent that as long as Rule 23 of the rules continues to hold the field, no promotion appointment of audit officer can be made by operating the said list beyond the period of 12 months after the list was published, approved by the APSC by operating the list dated so-and-so. The learned counsel for the petitioners in so-and-so has apprised this court that his clients have already assailed the validity of Rule 23 of the rules of 1995 as amended by instituting WPC 926, which is pending disposal before the division bench of this court. Under the circumstances, submits Mr. So-and-so, no order be passed on the merit of the claim of the petitioners at this stage, as otherwise the same would prejudicially affect the interests of his clients in the pending proceeding where the rules are under challenge. And in this context, now, if your lordship reads para 15,
14 also.
14, since there is no controversy at the bar that the validity of the list dated so-and-so, which was for a period of 12 months from the date of approval of the same by the commission, had expired long back, it is evident that no appointment promotion can be made by the department by operating the list dated so-and-so beyond the validity period of the list. To that extent, the grievance of the petitioners in WPC number so-and-so and so-and-so stands substantially redressed. In other words, in view of the stand taken by the department in the additional affidavit dated so-and-so, nothing further survives for adjudication by this court in WPC number so-and-so. Here, my lord, in these two writ petitions, what was under challenge is that this list is beyond the vacancies. So this has nothing to do with the validity of the select list by the unsuccessful candidate. Insofar as the plea raised by the petitioners in so-and-so is concerned, having regard to the peculiar facts and circumstances of the case and the nature of the controversy involved in this proceeding, this court is of the opinion that recording any finding on the merit of the plea raised in the writ petition would impinge upon the live issues which are sub judice in 926 pending before the court. It is in this context. The rules are apparently fallacious because the direct recruitment list will remain valid for all times to come. So therefore, it should have been actually 18-1 instead of 17-3 in Rule 23.
What is this order? They have annexed in the objection
I'm sorry, Maluk.
4999/2024 in the objection. Because I copy of the order 27/2013. 27/2000. When the petitions were disposed of? Yes, potato. 27/2039.
4999 is a challenge to the advertisement.
So 16/9/2024 advertisement, when a challenge was made, oh, sorry, while disposing of, it has said that at paragraph 17, well, from publishing the results of the selection process, the challenge was also that time.
Mal. Advertisement was challenged, but rule was not under challenge. Rule
Right.
was before the division bench. So
Right.
that
But
repetition was
advertisement,
Mal.
16:9, it was allowed to go ahead
Allowed to.
and
go.
not to publish the result of the
The
selection
difficulty
process.
is, my lord, let me point out. Our challenge is that once we have passed, in fact, may I place that rule itself? Ma'am? That rule will make the position very clear. Once a person passes if your lordship will kindly come to the,
I have understand, but paragraph, I have understood that, but paragraph 12, 13, 14, in
Ma'am.
a sense, how it has been reconciled, it is something,
I appreciate.
it is difficult once it is
But
held.
After all, it is before your
Let
division bench
the
now.
process go ahead, no result, final result.
But my problem is, the rule itself says that we cannot sit. Now we do not know whether we have to sit or not. If we do not sit, because the rule is very clear, that once you have passed, you need not appear all over again.
Let us see the advertisement. Is there any bar?
No. But the rule contradicts the advertisement does not make it clear. Page 191.
Hmm.
Now, the people who have passed, whether we are supposed to appear or not, if it goes ahead, we don't appear. Obviously, we need not appear under the rules.
That is subject to interpretation, definitely.
Yes. So that is why if the examination is allowed to be held, what will happen is our fate will be totally uncertain.
No, results should not be published.
In that case, my lord, the people who appear pursuant to the advertisement, they will say that we have already appeared. Now, how can it be? Their rights will come into play.
Did you challenge this one? These observations are also there, which is also.
My
some-
humble understanding is, in paragraph 15, the whole issue has been left open without making any comment.
But
And now that
categorical-
it is before the division bench,
It is observation is also there, because otherwise these two writ petitions would not have been closed.
there, my lord, the problem, perhaps why it was done was, the two writ petitions that were closed were by people who did not pass the examination. And they were saying that posts beyond the advertised vacancies could not have been, select list could not have been prepared.
So what was the advertisement?
Advertisement was for 32 posts and
So
select
you
list
are
of-
beyond 32.
we are beyond 30. So since a stand was taken by the authorities that the rule provides for 12 months and that 12 months is gone. So therefore on that, those writ petitions were closed as virtually infructuous.
Because they have got the relief with the observation.
Man,
With the observation,
man.
they have got the relief. Paragraph 12, 13, 14.
But again,
12
15
and 14.
and
And then at the same time, you have to reconcile this also.
yeah, if your lordship reads 13 with 15, my submission recorded
Yes, but if you read 12 with 14,
there's some amount of difficulty.
some
But
amount of
the
difficulty
issue-
is there.
But to overcome that technicality, we can always put those two paragraphs to challenge. But my understanding is, Madam, since now entire matter is before the division bench, your lordships can always interpret.
Because they were successful to an extent to stall the appointment
Man,
beyond 32.
beyond that.
And that was the observation made.
It-
And some way out is given in paragraph 15.
And if
To
the
keep
rule itself is struck down in this writ petition, our rights will automatically revive.
Yes, revive. But if think it over,
Man,
if 12 and 14 attains finality also,
that aspect is also.
you find out.
Man,
But so far as this is concerned, it can go ahead. There is no bar,
no,
but no results. It is not that no appointment, no results. It is not that no appointment. I am saying that stalling at the process, at the stage before results.
before result.
Before results. Subject to outcome.
No, already your lordship kindly see the same petitioner challenging the my lord, advertisement, my lord. They got that order. That order, my lord. Now, my lord, when my lord, they are challenging the rule, my lord, they another case they have filed, but not, then they are not stated that there is already the order is there. Already there is a order, my lord, passed by petitioner.
We have annexed it.
We have not annexed it. Actually, in the case, my lord, I have said that it is a second petition. It might, but probably this come to the, my lord, how it take with division, I don't know, my lord. So we go, I am concerned with the only, my lord, advertisement. So, my lord, we are go ahead as
What is
per
this, 4999? Mr. Chaudhary, 4999 already there in order
yes,
Yes, ma'am.
already there is order.
by the single judge
Single judge.
earlier. May go ahead with the process of departmental examination in terms of the advertisement notice dated 16/9/2024, if so advised, but shall not publish the results.
My lord. So accordingly, my
Still
lord,
without obtaining a leave of the court. It is already there.
so accordingly,
We-
go
we-
ahead and next week, my lord, all over Assam, my lord, different district, already arrangement has been made, my lord. So, my lord, your lordship kindly say already
So
protection is
it has
there. So
given
that
a
is
go
the
ahead.
order without modifying that, my lord, the same petitioner, right?
The court has already given a go ahead by this order. And it was not challenged at that point of time.
So that is his,
No,
his
The
order.
situation has not changed as on date.
But our anxiety is ma'am,
Right.
whether we should appear or not. That is why we
Yes.
thought that
But there is no bar because that rule 23, so long as it is in the rules.
but the same rule says that once you pass, you need not appear.
17.
No, in the schedule, well, if your lordship will, that is the problem that has, because the whole idea, 17(3) says that once a select list is published, as and when vacancies arise, if your lordship will kindly come to page 74, ma'am. In fact, my lord, Page-
74.
page 70 and 74. Page 70 at the very top, ma'am. No book will be supplied for any paper, any candidate failing in an examination but securing exemption marks in a paper will not be required to appear in that paper. So even if when one paper someone passes, he is not required to appear in that paper at all. So we have passed in all the papers.
No, that is not the correct provision, my lord. I'll place, my lord. Although it is not my duty, but I have to point out, but government can point it out, but the person, my lord, who is getting exemption mark, my lord. If he pass, my lord, all right. Validity to 1 year, he'll be appointed. If he's not passed, my lord, the exemption, your lordship kindly no.
Yes, exemption.
No will be supplied to any paper, any candidate failing on the examination, but securing exemption mark. That means, my lord, if you
No
get
book
45,
will be supplied for any paper.
no, suppose, my lord, suppose I am not passed, but I am getting 50% in a particular paper, the next examination I have to appear, my lord, on that paper I have not appeared. Only on that paper.
No book will be supplied for any paper. Any candidate failing an examination
But securing exemption, but securing
in a
exemption.
paper.
What happens to a
Will
person
not
who
be
gets exemption
required.
marks in all the papers?
So if you got exemption in all the paper, my lord, you will pass, my lord.
So that is what I'm
But
saying.
that
We
is
have
not,
got,
that is not mentioned, my lord, there. So as by, that's why they challenge the rule, my lord, now.
if your lordship will kindly come to page 69, it will make the position clear. So overall pass percentage is 45 and individual papers, a person is required to get 50 marks. So that is known as, they are calling it exemption marks. So anyone who gets exemption in a paper, 50 marks and above, he need not appear in that paper again. So by that analogy, anyone who gets exemption marks in all the papers, he need not appear ever again. We have got exemption marks in all the papers.
Minimum marks required for passing. What is this, page 69?
Page 69 is the
Minimum marks required for passing.
mark.
All are in 40%, at the bottom 45%. What is that?
That is the overall mini aggregate to get to pass. But individual papers,
Percentage of exemption marks, 50%. What is that?
so if anyone gets 50%, he will be exempted from appearing in that paper in the next round of examination. So assuming a person does not get the 45% overall, but he gets 50% in 4 papers.
Okay.
So next time, when the examination is held, those 4 papers he will not have to appear. He has to appear only in the remaining 4 papers.
So from that you are drawing the thing that
We have
you
got-
may not have to appear.
We have got 50% in all the papers. So how can we have,
But suppose it snapped at 12 months for all?
no, the again, we have to fall back on the rules because the rule does not say it will be once a list is published, as and when vacancies arise. If your lordship comes back to 17.3, language is very clear. Once, that is why both the rules have to be read together. At page 61. 17.3. The Assam Local Fund Audit Service Promotion Examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such intervals as the appointing authority may, in consultation with the Commission from time to time, determine. If I may pause here for a moment, my lord. Unlike the normal rules for promotion, it does not say that it has to be held every year, only when, as and when determined. A list of candidates who have qualified in the said examination shall be prepared by the Commission in order of merit and forwarded to the appointing authority. Promotion shall be made from the list subject to availability of vacancies. So once a list is prepared, as and when vacancies arise, they will go on appointing. And it absolutely tallies with page 70, this provision. Because if a person has already passed, where is the question of him appearing again? And that is what has been followed by the department all through. We have given those examples also. And the other problem that I was pointing out, if we read sub-rule 23 to mean 17.3, it will leave the direct recruitment select list valid for all times to come. There is no such prohibition for the direct recruitment. So therefore, this is I think it's a case of simple typographical mistake.
Could be.
Because otherwise, a peculiar situation arises, madam, that a direct recruitment select list can remain valid even after the person attains the age of retirement.
It could be sub-rule 2 of rules 18.
Exactly.
Could be.
Should be.
Could be, not should be. As on that, not should be. But you have gone with the situation with the previous order.
I'll leave it to your lordship. I'll leave it to you.
So let it be like that. Situation is not changed. It is a part of the process. Examination.
In that case, my lord, your lordship will maintain that order and
Ah.
fix a date for disposal. Let the finance department file the affidavit as they had prayed for in the
Who has
past.
filed this objection?
APSC is a formal party, man.
We are concerned.
They are conducting the exam.
Exam, only exam, man. Because exam we go ahead as per order of the honorable court.
You heard Mr. I. Chaudhary, Land Senior Counsel. Listed by Mr. R. Sinha. Land Counsel for the applicants. Lead petitioners. And who is part of finance? Miss, yes, you have to say anything. They have filed their affidavit or not?
No, on the last occasion, they had prayed for time, but not filed.
Very good, P9 your lordship. And affidavit is ready, your lordship. We have sent it for signing for 2 weeks time.
Miss
RM Bora, your lordship.
R.M.
It's the P9.
Land Counsel, representing Mr. P. Nayak, Land Standing Counsel Finance Department for the opposite party. That's respondent number 1 to 3, and Mr. T.J. Mohanto, Senior Counsel and Training Council APSC, stated by Ms. P. Sharma, Land Counsel for the respondent number 4, 5, 6. Okay. RM Borwa is also 7. The applicants as read petitioners in the connected repetition, WBC number 926/2025. As challenge a virus of Rule 20 within bracket 3. Of the Assam Local Fund Audit Service. Rules, comma, which year? 1985 as amended. Full stop. The applicant's petitions has also laid a challenge. Here it 4999, what you have challenged?
The advertisement.
Has challenged an advertisement dated 69/2024. Whereby it was notified that the respondent Assam Public Service Commission would hold a departmental within bracket promotion examination for the assistant audit officers who have completed at least 3 years of service as on 1/1/2023 for filling up of 53 number of posts, including backlog vacancies, etc. In accordance with the Assam Local Fund Audit Service Rules, 1997 as amended. Post para. Pursuant to the advertisement dated 69/2024, the APSC has published a notification date on 11/4/2025, whereby it has been notified that the department within bracket promotion bracket close examination for the post of audit officer within bracket local fund bracket close Assam under the finance department pursuant to the advertisement dated 69/2024, would be held from 17th June to 21st June at the office of the APS. Mr. Chowdhury, and Senior Counsel, appearing for the applicant's petitions, has submitted that since Rule 20 within bracket 3 of the so-and-so rules is under challenge, the further process in respect of the departmental within bracket promotion examination, as notified by the advertised notification dated 11/4/2025, B suspended as from the provisions of the rules. It is apparent that once an assistant audit officer appears in a departmental within bracket promotion examination and passes the same on the basis of passes the same in terms of rule 17, rule 17(3), comma, there is no necessity for such an assistant audit officer to appear once again in the limited departmental within bracket promotion examination. And the notification, and therefore, the notification dated 11/4/2025 is clearly prejudicial to the applicant's petitioners, as they have already passed a departmental within bracket promotion examination previously held in terms of an advertisement dated
Original appointment.
original advertisement
3/5/18.
3/5/2008. Para Mr. on top line C, that's like waiting for the respondent APS has referred to an order dated 27/9/2024 passed already in the connected with petition WPC numbers 4999 of 2024, wherein the applicants, present applicants petitioners have laid challenge to the advertisement dated 16/9/2020. Also, by the order dated 27/9/2024, the court, after having regard to the facts and circumstances of the case, had passed an interim order allowing the respondents to go ahead with the process of departmental promotion examination in terms of the advertisement dated 16/9/2024. If so advised, with a further observation that the respondents shall not publish the results of the selection process, without obtaining the leave of this court. Post up. He has further submitted that the situations have not undergone any change, save except the challenge made to the virus of Rule 20 within bracket 3 of the so-and-so rules in the meantime by the connected writ petition WPC number 926/2025. Postal. Para. Having regard to the submissions made for the council for the parties and the sequence of events, more particularly the order dated 27/9/2024, this court is of the primacy view that the departmental examination, promotion examination scheduled on 17 of 6/2025 to 21/6/2025 does not call for any interference at this stage as by the order dated 27/9/2024, single judge had already allowed the respondents to go ahead with the process of departmental examination in terms of the advertisement dated 16/9/2024. First up, the question as to whether the applicants, the petitioners, need not appear in a departmental promotion examination once they have passed an earlier departmental promotion examination would be a matter of adjudication in both the writ petitions, WPC number 4999/2024 and 926/2025. Post of in the interest of justice, post of Nagaya. There is no bar. There appears to be no bar in the advertisement dated 16/9/2024 for the petitioners, applicants petitioners to appear in the departmental promotion examination scheduled from 17 June 2025 onward. However, for balancing the interest of both the parties, it is ordered that the results of the departmental promotion examination shall not be published without the leave of the court. Full stop. Dispose of this one
I can be disposed of. In the main.
with the above observation directions, the instant interlocutory application is disposed of. Full stop. Ms. Borua, you say that it is here counter file.
In 4999, it has been. 4999 is conclusion. I don't think they have filed in any, both the repetition.
If they file consolidated, it is okay.
Yes, my lord, one affidavit.
One affidavit will do. Miss Borua, Miss Borua. You have filed APSC?
APSC is filed.
Advertisement yet. So if my lord, now they are selecting the rule, man.
The rule is for them. Ms. Borua, when it is expected?
Kind of.
2 weeks. It will go after vacation then.
A fixed date may be given. And your lordship will make an observation that an endeavor will be made to dispose.
I don't know about the court, but let them file first. Can you make the prayer?
Mar,
2 weeks may extend to 4 weeks also. I don't know.
I don't think so.
Our
because
Mr. I
have already taken time.
Senior Counsel, assisted by Mr. R. Sinha, Learned Counsel for the petitioners. দুইটাই লিখে দিব, WBC দুইটাই লিখে দিব. And Ms. R.M. Borua, Learned Counsel representing Mr. P. Nayak, Standing Counsel, Finance Department, and Mr. for the official state respondents, and Mr. T.J. Mohanto, Senior Counsel and Standing Counsel APSC, listed by Ms. P. Sharma, Learned Counsel for the respondent APSC authorities. Ms. Borua, Learned Counsel, preparing for the respondent Finance Department authorities have submitted that the counter affidavit on behalf of the respondent Finance Department authorities have already been prepared and sent for vetting. And the same will be filed within 2 weeks' time. She has thus, Ms. Borua has thus sought for listing of the case after 2 weeks. Having regard to the fact that the virus of Rule 20, which is bracket 3 of the so-and-so rules is under challenge, place the cases on
23rd, my lord, if it is not inconvenient.
23rd July. 23rd July. Okay, shall we observe the interim order passed in so and so shall operate in the meantime? The interim order passed today. Date to likhi dibo, bracket or bhitor, 4999, passed in IAC number 1424, 2025. Shall operate, 1474, okay. Shall operate in the meantime. Like.
Four orders. Item number 4,
And Senior Counsel Narration Public Prosecutor, listed by Ms. R. Das and its counsel for the respondent number 1, and Mr. N.K. Das and counsel, legal counsel or learned counsel for the respondent number 2, that's informant. You be prepared on 19th. First of, having heard the land counsel for the parties at some length, this court is of the constituted view that since the paper book is ready, an endeavor can be made to hear the criminal appeal, full stop, on 19/6/2025, full stop. Release the case accordingly on 19/6/2025. Full stop. It is observed that in the event the appeal could not be heard on the next date, an endeavor will be made to consider the application consider the interlocutory application IAC number so and so. 4-2 you have made out a case.
Hello?
4-2 you have made out a case. Para 30 also you have made out a case, but so far merit is
That's
concerned,
what
we
I
understand.
understand, But merit also I have a case now.
And if it goes down, then it goes down.
But merit I have a case now.
Merit will see.
Same day doctor examination, same day required from with the victim. She was with the victim as per her that with the
Okay. Etu the procedural demand asil. 21. Okay. P. Prasad and Micah Security for the appellate and this R. Kosik Learning Council for the additional public prosecutor for the respondent state. Are present. List the case on Thursday and Thursday as part of for further hearing.
She is seeking other methods.
This will not be possible because I think Mr. Kotogi's case was there. We'll come back. You want postponed? No, it will come, serial will be after.
item number 6,
May it please your lordship. Lordship, on the last occasion, records of sessions case 77 of 2018 had been burned. The office note indicates it has come.
It will for you. Let both the appeals be listed together to find out. Right.
We've otherwise checked it is corresponding to the present appeal.
The other appeal is also arising out of the same judgment perhaps.
Lordship, I think it was perhaps wrongly tagged with the other appeal. You checked the records, it has come.
Oh, okay. So, where is the judgment here?
Lordship, in this case,
Should be No trial court record.
page 12.
Sonji Bonik. Sessions case number 77. 2018. Rajiv Bonik. Go ahead. Here is number. One ninety five to a valid. Take to put over the take to get the a this is or better good. 190 5 to 8. Two connection. Heard Mr. A. Trial and Council for the Appellate and Mr. R. Posting learning additional public prosecutor for the respondent number 1, state or so. In terms of the previous order, dated 35/2025, and office note dated 23/5/2025, the trial court records of sessions case number 77/2018, arising out of Borpeta Station Road Police Station case number 432 of 2017 and ZR case number 4934 of 2017, comma, are tagged with the case record Pustav on perusal, comma. It is found that the trial court records of session case number so and so, sessions case number 77 of 2018 are relatable to the present appeal. Pustav office to prepare the paper book. Office to take steps for preparation of a paper book. First of the case after 4 weeks as regards readiness for a report as regards readiness for the. Blessed.
Item 7 and 8.
In both cases, your interlocutory application is pending. And on the other day also, when I have submitted one compilation, probably it is there in the record.
Compilation.
Compilation. Translated copies of the deposition and other exhibits.
Appealing is conviction.
Lordship.
Compilation. What is a compilation? I,
I had 27 and 33. Two ILs are there, and in one case, one of the person is lordship granted bail on medical grounds.
Hmm?
In item number, in IA 33, one of the accused, Azad Ali, was granted bail on the ground of medical condition. Total 8 accused persons before your lordship.
okay, I see. Not 32, 32. Okay, 8.
8. Out of 8, one is on bail on medical ground.
Huh? Who has been
Azad
granted relief?
Azad Ali.
Huh?
Azad Ali.
Azhar Ali.
Lordship.
By which order? I number 32. Which one?
IA criminal 32 of 24.
Date 11, 12. Yes.
Lordship, may I kindly see page one, that is the FIR, then I will submit on the other points. Lordship. First, let us see the prosecution case. Lordship. Page one is the FIR.
Of that paper book
Compilation. Lordship.
compilation.
Yes.
FIR.
FIR. Lost by PW1, that is Abdul Bapen.
Hmm?
Lost by brother of the deceased, that is PW1, Abdul Bapen.
PW1.
Lordship, Abdul Bapen. I have the honor to state that around 8:30 PM on 19/6/2013. So date of occurrence, Lordship, may I kindly know. 19/6/2013, when my two brothers, who is Abdul Hamid, he is the deceased, and Mufazzul Haq, he is PW9, were coming back to the house by riding a bicycle after closing their shop at Bongalmarapara market. The below cited accused persons who were lying in an ambush all on a sudden attacked them, my two brothers, on the PWD road near Tulapara Kabristan graveyard and Durga, caused grievous injury on various parts of their bodies, including head, by beating them up by means of lathi, rod, etc., and stabbing with sharp weapons, and snatched an amount of rupees 35,000 from them. Though both of the injured persons were admitted to Bilasipara Hospital, they were referred to Dhubri Civil Hospital for better treatment. As their condition was critical, later on the injured persons were sent to Lower Assam Hospital, Bongaigaon. Now here, 6 persons were named in the FIR. So the date of lodging of the FIR, here you also will find that 26/2013. But Lordship, may kindly see the Xerox certified copy I have enclosed, that is at 3A. Those were sent to the magistrate, concerned magistrate, only on 24/6/2013. Why this is relevant, I am coming to that, Lordship. 24.
What you are pointing out?
In top portion, your Lordship will find that magistrate put his signature, seen signature, page 3A. Top portion, right hand side, 24/6/13. Similar, your Lordship will find in the main contents of the FIR also next page, top portion, right side, 24/6/2013. So it was placed before the concerned magistrate only on 24/6/2013. So whatever they did, they have put, I am not, at this stage, I am not disputing, but other facts, Lordship may kindly consider that one Udal Bakra GD entry was made by the PW9, that is the brother Mufazzul, the person who was accompanying the deceased. He made a GD entry to Udal Bakra, that your Lordship will find page 6 now.
Mm-hmm.
Page
Who,
6.
who?
That Mufazzal, who was accompanying the deceased.
Yes.
So he lost and one GD entry, that page 6, Lordship may kindly see. Lordship. He said certain miscreants. He named no one.
Hmm?
He mentioned about certain miscreants. He did not name anyone. And this was exhibited, and the concerned investigating officer of that police station was also called to prove these documents. Now, inquest report, your Lordship will find page 7, that is in relating to that GD entry which he made. Page 7. Here also no names mentioned, only they
No,
reported
this ZD entry is on which date?
23/6/2013.
This then it should be, this is not 29, it should be 19/6 perhaps. Third line.
Oh, yes, I'm sorry, that's 19/6. Typographical error.
But it is material.
Lordship. 19/6.
1 minute. let me read the vernacular one.
Regular page 6 here also.
Please take care of these dates.
Lots of. And as per the GD entry, he died on 22/6/2013. That is also relevant because your lordship will find in the postmortem report, one fatal blow was there and 8% is convicted.
Put the page. Hmm. Hmm. Yes, yes, for me. Put- It was a relevant thing. It was a relevant thing. Hmm. 8 লিখিত দিয়ে লিখিত এইটো ভাৰতৰ বিষয়ে উত্তৰ বাৰ্তা এইটো আউটপোষ্ট where the incident happened.
According to them, lordship.
Jurisdiction.
The Bongalipara market, that is under.
Which
Bilasipara-
district?
That is under Bilasipara, Dhubi.
Bilasipara.
In the FIR, it is mentioned.
Or Bilasipara. So what is page 6?
Page 6 is the Udalbakra.
Page 5, page 5.
Page 5, lordship, this 5, they said, lordship, that initially it was informed to the PS on 19 itself.
Abdul Hamid.
Yes. And the injured were sent to hospital, but no FIR was lodged, nothing
Ah.
was there.
That is the information.
Only information.
Hmm. And the injured was sent
Sent
for medical treatment
for medical.
at Bilasipara SHC.
Yes.
Okay. And this entry, this page 6 entry,
Lordship.
page 6 entry is at Udalbakra
Udalbakra.
after the death of Abdul Hamid
Lordship.
at Hayat Hospital, Udalbakra.
Yes.
On 22/6 he expired and morning the written ajar. Okay. This written ajar.
My whole case is that, lordship, they, after the death of the victim, lordship, they informed the police on 23/6/2013 that without naming any person as accused, lordship. And subsequently, this FIR was brought on record, lordship, naming all the accused persons, lordship. That is what I was trying to point out before, lordship.
It could be hit by section 162
Lordship.
at best.
Lordship.
It could be his, the FIR. Yes, there is another issue.
But
Maybe the scene part will examine later on.
Lordship.
The scene part,
Lordship.
but this was done on which date? The FIR was lodged on which date?
It is mentioned as 20/06/2013.
20/06. And where is the formal part?
Form, your lordship will.
Form
Form. Page
20.
3. 3A.
3/8.
Lordship.
Other than the scene part,
Lordship.
this FIR was lodged prior to GD entry,
Prior to GB.
this 527.
Lordship. Therefore, I have pointed out that scene part.
Hmm.
And the PW9 who was.
Yes, PW9.
Yes, PW9 who was treated to be as.
And
injured.
what you have pointed out regarding inquest?
Yes.
Inquest is at Udalbakra.
Yes, the inquest at Udalbakra. in presence of PW9.
Marks of injury and bandage are found, not an injury on a body is clean and reported by assaulted with others. Feel that mutually into is last.
In page 7A, your lordship will find that signature of witness Mufazzal Islam, he is the PW9. He also did not mention about anyone's name. And postmortem was also conducted in connection with the said case. They have also not mentioned.
Where it was conducted?
In connection with that Udal Bakra.
Where?
That.
Guwahati Medical, GMCH.
GMC.
Yes.
In
What is
connection
the
with that DD entry of Udal Bakra. They
head
have not mentioned
injury?
anything to the Udal Bakra OP that they have already lost their case at Bilasipara. That was not intimated to them.
No, what are the injuries? As
Injury
per
was
do
head
you have
injury.
typed it out? Have
Yes,
you typed it out?
Doctor's evidence, lordship will find page 45.
Yes. That likhito
Lordship.
by Mokojul
Lordship.
was exhibited.
Yes, it was exhibited, that OP.
Where it is?
That your lordship will find DW6 evidence, page 59. I'm sorry, lordship. That is. Exhibit page 59. Exhibit B2.
Hmm?
Page 6 is exhibited.
No. That is GD entry. This Mokojul gave in writing, they are saying, as per a GD entry.
Exhibit 7.
লিখিত দি জনাই
Exhibit 7 is the certified.
এইটো GD entry মাৰি লিখিত দিলে তো জুৰিটি ঠিক নাই মৰিছে লিখিত বুলি ক'লে তুমি এইটো ওলাল ৰাখা এটা হায়াতত মৰিতো হায়াতত মৰা দেখি কিন্তু লিখি দিলে এটা দিব পাৰিম সেইটো সুধিছো লিখিত থিং পেজ 6A মফজুল ইছলাম এখন চকীত এখন লিখিত দি জনাই যে was it exhibited?
That Lishito part, Lordship, probably is not exhibited.
Huh?
And in fact, this question was put to him, PW9, he also admitted that he informed. This was confirmed to him.
Giving information is one thing because he died here.
Lordship.
He died here, Hayat. And place of occurrence was at Bilasipara. For what purpose? To conduct post-mortem examination also he could give that whether that is there.
That right.
That was not exhibited.
Not exhibited.
Okay. Now PW9.
And in PW9, your Lordship will find at page 31. Director Lordship goes back PW.
Mr. Ahmed, what's strike in my mind in the third line.
Yes, it is PM, Lordship. Instead
That
of AM.
kind of
PM. But I have checked, but I forgot to mention it.
I can take the view it is deliberate. I can take the view it is bona fide. But I have immediately I saw because I remember 8:30 PM
Lordship.
as per the FIR.
Lordship.
Then why this 7, 8 AM, knowing fully it is clearly PM in the vernacular 31D. This kind of
Right. I will-
confusion should not be created before the court. That is why I repeatedly say I don't know. Nowadays I stopped believing the translation
That point I will also
until the registry makes it. I have been repeatedly saying, I have found it everywhere. I have imposed cost also. I have started also, I have made made it clear to all. Now I'll start imposing cost because it changes the narration, entire narrative.
Lordship.
I thought that it is a very good ground initially.
Lord, I have not taken that plea.
No, it strike my mind.
Lordship.
Apart from your plea,
Lordship.
court has the
Yes, I understand. I'm sorry.
court has to individually apply its mind to the facts of the case.
Lordship.
This is not proper. I don't find this. This now I have seen on 2 occasions now, and how should I believe? Because this is very illegible. This is fortunately at least clear, say in English, 7/8 PM. In page 31D.
Lordship.
Mr. Ahmed, you should, you are a senior lawyer, you should at least ensure yourself.
I'm sorry, I will check.
This I do not encourage this kind of thing, and this is not appreciated by the court. This does not look good. These are uncertified things. Why should we believe now?
Certified copies I have given. Lordship.
No, why should we read those? Can you read page 31D? Fortunately, 7, 8 PM I can read.
Lordship.
But other things, can you read? You start reading. Possible. Possible for your part, on your part.
There are
It is not possible for, on my part. Good, wait. Okay, let us see.
And the paper will be printed or share series that.
This is difficult. একো বুজি নাপায় এইটো কাৰণ মই ইংৰাজীকলৈ ইংলিছ নপঢ়ো we বুজি নাপায় to verify also. Mr. Azhar, we can make effort, but it is difficult to compare.
Even if your lordship takes from the judgment lordship that a specific allegation is against one Rohimul. From in the judgment also that PW9's deposition is quoted, from that part also your lordship will find it is only against Rohimul and one injury is there.
Only. You must have been. অলপ গ্যাপ দি লিখিব পাৰে অলপ গ্যাপ দি লিখিব পাৰে অন্ততঃ পঢ়িব পাৰিলে ডাঙৰ ডাঙৰকে লিখিব পাৰে Huh?
Paragraph 16, the deposition of PW9 is there.
Is he the same judge who wrote this, recorded this deposition?
No, different judge,
Huh?
different judge.
Itu ধার্মিক করে লিখেছে MCTR এইটুকু PW9 কি বুঝি পাইছে ভগবান জানে হুম? হুম? PW9 নাম তো লেখা হয়নি মনোয়ার আলী মনোয়ার আলী মনোয়ার আলী Let us see what you have translated of PW9. Is this man was injured?
Mofajal was.
PW9.
Yes, he was in
Where is his injury report?
injury report, but
Page 8. This was dated 19/6, 9:30 PM. Simple,
Caused by blunt,
simple,
caused by blunt.
blunt object. Swelling. Where is this 164 statement?
64, sir, I have not enclosed.
Doctor evidence or testimony?
PW 18, page 45.
It is 164 statement like that. 164 statement Mokojul. Islam. What is the IO?
PW 12, page 38.
PW 12 and 13. Page? That was on 510. He started investigation on 510.
14 is also there.
Huh. This is also on 28/1/2024. Incident is of
Oh, it's there.
which one? PW? Oh, again, the same handwriting. Same handwriting. Was the question about this sending the FIR to the magistrate?
That specific I have not found. Also.
Yes, 43 is now. 43 of them. The disease was examined at 9:30 also on the date of the incident, page 43.
Yes, we examined.
On that very day, after 1 hour.
Also.
Thereafter, his date was resulted in 22nd or 23rd at Guwahati. But fracture of left forearm, lacerated cut over skull on the left side, leading to heavy severe bleeding. Then in his cross-examination, but it is quite impossible that more than one injury of this type can be caused to a person if falls on the ground. So far injured is concerned, he also sustained an injury on blunt object, by blunt object, which is telling with the injury report. Now here is a case of an injured witness.
Injury.
They are at the higher
Yes.
pedestrian
Yes.
than the normal witness. Why his thing is to be disbelieved?
Initial point, what I am placing for lordship is that at initial point of time, he did not disclose about those names to the Udalbakta OP lordship. And in the deposition also, your lordship will find that he attributed that Rohibul Islam caused the head blow lordship. That your lordship, from his evidence itself, your lordship will find. 64 to পড়া কেটে দিয়েছে। And the person died after 3 days, lordship. So if they.
Whether that would come or
No,
not, that is a
only
matter.
for the purpose, lordship, for other persons, that they were implicated under section 149.
Yes,
Apart
149.
from Rohimul. So if
149.
they had the common intention to kill the person, then lordship, they would have killed. Otherwise,
That would be a matter of interpretation, appreciation. But in his 164 statement, he has named everybody, all this,
Yes.
everybody. All 8.
yes, but the evidence.
One
in
by one.
evidence, But in evidence, he attributed to one. Because probably that was noticing the injury part.
Because 164 is for corroboration as well as for contradiction,
Something.
unlike 161.
But,
And he has brought in on record.
but. And in chief, he specifically named that Rohimul dealt the blow on him.
Yes.
And
Right.
one more thing, your lordship will find that in the initial stage, it is alleged that all the accused persons snatched the money. And thereafter, when the deceased raised a protest that Abdul Hamid assaulted. So Rohimul assaulted lordship, that Abdul Hamid deceased. So
No,
now,
what is palpable?
lordship,
Those are some subsidiary thing. What are the palpable things?
from
389, we are concentrating on the palpable, which is apparent, just looking at the
lordship.
documents and testimony itself, which is apparent.
So that is why I'm.
Because We are not going into nitty-gritties of all these. What are palpable things? You point out 1, 2, 3, 4, we'll take into that.
The first, Lordship will see that the delay in sending that FIR, Lordship, connected because of that in the.
Yes.
delay-
Yes, what is the law on that point?
that-
Otherwise,
that,
it is,
if FIR
it is to be sent
forthwith,
immediately,
forthwith.
right? If delay occurs, what is the
The
prejudice?
delay along with the other circumstances. Because
Ah,
other
but
circumstance here.
Let us see the delay.
Lordship.
What is the prejudice which is caused?
Prejudice, Lordship, because Lordship. that
Which
is
provision is to send it to the FIR,
One-
the FIR to the
157.
magistrate? 154?
Yes.
154, here. So, 2013. Okay, it was fully work, fully. Information, so and so. Information regarding shall be given for the free of cost, anybody, so and so 9. It is not going to. It is 157. Mere delay in the dispatch of the affair itself is no ground to throw away the prosecution case in its entirety.
Yes, I'm not saying that. that this is
Sending
the
the
sole
report
ground. That because of
is
the.
a circumstance which provides a basis to raise a suspicion that the affair is the result of consultation and deliberation, and it was recorded much later than the date and time mentioned in it, and disclosed that the investigation is not fair and forthright.
Therefore, I have pointed out to your lordship
Okay.
that Udal Bakra GDM, so those circumstances. That initial stage, that it was not reported to the other police, that these are the assailants. And even the inquest report and the postmortem also conducted in connection with that GDM. They have not said that another case is already registered or informed to the concerned police station. They have not informed about this case now. And
Initially, the case was registered under which section?
initially it was registered under 326, 325, 394, and subsequently 302 was added.
Yes.
143, 341.
On 25/6/2013.
Yes.
Itu কেনেকে 24/6 যদি হয় এই added 25/6/2023 কেনেকে হ'ল ফটোকপি দিলে বা চাৰিকপি দিলে হ'ব পাৰে চিন কৰিছে তাৰপিছত এইটো ভিতৰত এইটো 25/6 লিখিলো edit, into edit section, 302. Wait over there. It's not the original. Anything that is one
That is
suspicious.
suspicious. And second thing, your lordship will find that there, the prosecution tried to, the prosecution, the defense side proved that there was dispute between the deceased and other person because he was the agent of Falcon Company who took, who misappropriated some money, lordship. And regarding that, there was some altercation. And third ground, lordship, that my ground is that, lordship, that PW9, who is said to be the sole eyewitness in the present case, lordship, as per FIR. And lordship, he specifically named lordship Rohimul. Regarding Rohimul caused injury in the head of the deceased, lordship. And regarding other persons, what was their motive to snatch away the money or to kill? That part is silent from his evidence, lordship. Because the victim died subsequently after 3 days. So what was their motive? So if their motive was to snatch away, so they cannot be convicted under section 302, lordship, for abetting the Rohimul, who exceeded the common object, lordship. And from PW9's evidence, there is no specific allegation against other accused persons, lordship, regarding their roles played in that case. And it is admitted by PW9 that he lost the case before Udal Bakra without naming anyone.
He admitted
Admitted,
cross-examination.
yes. And only after registration of that FIR, the present FIR was sent to magistrate. The initial GD entry, which was exhibited by prosecution, that page 5, there are also no mention that this person had assaulted. No information was given. Even the deceased was alive, no dying declaration was recorded. The injured was there before police. He did not recorded his statement. Nothing was done on 19th, page 5. At page 5, your lordship will find that both injured Abdul Hamid and Mufadzul Islam both son of so-and-so, PS so-and-so are sent from this PS to Bilasipara SHC. So they were present at the police station. He did not inform the police about the assignment, nor the statement of that seriously injured person was recorded by the police.
Yes.
Points taken by the learned friend is a point which can be taken up at the time of hearing, your lordship. We will deal with delay in lodging the FIR. And your lordship, apart from PW9,
So it is not delay in sending the file.
delay in sending.
That is one part,
My lord,
right?
yes.
On 24/6/2013.
Yes,
That is one.
Right.
Magistrate saw the scene, recorded scene on 24/6/2013. That is one. Delayed sending order.
yes.
When the provision says forthwith,
Okay.
right? And there is another one that's this PW9, the disease expired in Guwahati. So as per the subsequent GD entry, there is one GD entry on the date itself. Medical treatment was provided according to that GD entry to both the injured. Thereafter, they were taken to Guwahati, from one hospital to another, ultimately to Guwahati, where the disease expired, right? So that second GD entry at Udal Bakra was recorded on the basis of a written something from PW9. And the defense is saying that in that Likhito, we don't know what is Likhito, what is there. He did not mention. So that is a fatal circumstance for the prosecution. That is what
My lord.
they are projecting.
Apart from it, there are two
And
eyewitnesses.
plus the testimony of PW9 before the court,
Yes.
he
And-
said.
Yes, and there are two other eyewitnesses, PW4 and 6.
Is it?
Yes, my note says. So.
You don't know?
4 and 6 relied on by the trial court, but their statements, lordship, no specific allegations are there, and it is not corroborated by medical evidence.
21.
Yes, 4 and 6.
When?
4 and
4 and
6.
6.
After
PW4
also.
page 22A.
Okay, 164 is recorded.
They don't annex the 164 statement. Your Worship. Where the paper book be prepared, I'll still make a submission. Its entire records are not before your Worship. 22B,
PW4.
PW4. According to him, he witnessed-
PW4. This part is 22A is what? Cross-examination.
process-
Or PW English. It is in English. Chief is in English. Chief is in English.
Chief is in English. Cross is in Assamese, therefore I have to.
I don't know whether it's a type two on your Lordship, because.
No,
no
page
signature.
21, page 21.
Please,
21.
yes. Here he says, I was standing there when I saw the entered incident. Fourth line from the bottom. I saw assaulting and hitting by the accused person and they left after the incident. After the incident, I found Abdul Hamid unconscious state. Accused person had hit on the head of Abdul Hamid very badly. There was profuse bleeding coming out from the body. His hands and legs were broken by the accused person. There were cut injuries on his chest. Mufadzil Haq was also lying on the ground. Fazil is the injured eyewitness. He was also injured, but Abdul Hamid was seriously injured.
Let us see the doctor who examined on that day.
PW 17.
Lordship, PW 70.
Doctor
Doctor who examined the injured.
on that day itself.
Page 43. Fracture of left forearm, lacerated cut
And
over.
what is the injury report?
Injury report they have annexed. It's on medical examination page 8.
Page 8. Page 8. What you have elicited from PW4?
They have witnessed the occurrence, my lord. That accused persons were very much.
No, what the defense had elicited?
Lordship with this process. Not the fact that I did not state to the magistrate that the accused person broke the skull and legs of Abdul Hamid and failed Mufazzal into a ditch after making assault to him. And I immediately informed my father over phone. So they talk about the 164 statement.
Hmm?
They talk about the 164 statement.
Who?
Just no, lordship, that they have not stated before the magistrate. Maybe they talk about 164 statement. There
Okay,
might be
which part? Which part?
22B minor. It is not a fact that I did not state to the magistrate that the accused person broke the skull and legs of Abdul Hamid and failed Mufazzal into a ditch after making assault to him, and I immediately informed my father over phone. It is not a fact that I did not tell the magistrate that we altogether took the injured person to hospital. It is not a fact that, though I remember I have concealed the truth, it is not a fact that I did not state to the magistrate that we took the two injured to Bilasipada and Dhubri hospital and then to Lower Assam hospital. It is not a fact that I did not state to the magistrate that all the accused persons altogether assaulted my uncle.
So if he had denied the thing, then it was a duty of the defense to bring it on record, that part.
Yes, page 35C, your lordship will find.
Yes, and it,
In fact, PW4 in,
we are not hearing the appeal, sir. We are hearing the I only.
my
We will
learned-
not spend more than 1 hour.
The procedure
Yes,
lie with strong.
Regarding 149, that the facts and circumstances of the case, whether there was common intention or not, at this stage, my whole submission before your lordship is that cannot be considered without going through all evidence and lengthy hearing. So, my lord, under the facts and circumstances, what is revealed, my lord, that there is a common intention. And regarding this, my lord, the sending of the FIR lately, my humble submission before your lordship, it will not damage the contents of the FIR. Because FIR was filed on 26. So it is sent to the magistrate lately. There may be some delay. What is the delay that will come from the IO? And your lordship will consider when IO was cross-examined by the defense.
He was not cross-examined.
On that point, if
On
that
that
is not,
point, perhaps not.
that was not considered, that was not cross-examined, IO was not cross-examined. That point is to be looked into. Because why delay? That explanation can be given by the IO. So, my lord, regarding another aspect, my lord, the GDNT in Udalwakra. GDNT in Udalwakra. Your lordship will be pleased to consider that his brother died in the hospital. Immediately, that was a formality for post-mortem. He make a GDNT that my brother died. But he did not mention there the name of the accused. At that time, my lord, to naming the accused is not the vital. Vital thing is this, my lord. When they were assaulted, he was accompanying his brother. And brother was brought to hospital. Brother died. Own brother. He just go to the Udalbakra outpost just to perform the postmortem report, etc. But mentioning, my lord, in 26 FIR, my lord, all the names of the accused persons. Here in Udalbakra, not naming the accused person will not damage the FIR. That is at the first hand. First hand names are there. So, my lord, my humble submission before your lordship is this. These all things, all technicalities will be taken at the final hearing. But it is a gruesome murder, my lord. So, regarding bail,
Not gruesome murder, he died later on.
it is a murder and he died later on. But
That intention,
was-
knowledge, that part we'll consider later on.
Your lordship will consider another thing. My learned friend pointed out why his dying declaration is not there. It is, he was unconscious condition. No question of dying declaration is yet open. So, my lord, overall, this is the submission. My lordship.
Think also it is why-
Yeah, I mean,
Only one thing, if your lordship permits, I will not take much now, only one thing, your lordship, may kindly for on page 35C.
that is a danger. Translated copy.
I have checked it, it is correct, lordship. That part also I can place with your lordship, that even part. That 1, 2, 3, 4, fifth line from top, lordship. PW4 Akhtar Hussain told me that Mufazzul Hussain was an agent of Falcon Company. That Falcon Company was closed. That there were incident of fight with the person who deposited money. That a case by 553/2013 was registered in this regard. And that incident took place on 17/6/13. And that 17/6/13, that part your lordship on page 37 in vernacular. The date of incident is 76/13.
There was another incident where you were the informed.
Lordship. So,
Is it not?
lordship. That
But it is not a cross case.
cross code.
Not a cross case.
No, that their incident, one incident occurred on
there was
17
incident.
6. That is what, therefore that regarding injury also, doctor was put question whether he mentioned about the age of the injury,
Maybe in retaliation, but not a cross case.
not a cross case.
There is one FIR mentioned already.
Cross.
There was one FIR from your side,
No, from our side. That is on 17 6.
17/6. This incident says
It is on
19/6.
12 19.
Yeah, I'm for the applicant's appellants. Be real and senior counsel. An additional public prosecutor for the opposite party, number 1, State of Assam. And Mr. M.S. Then counsel for the opposite party number 2. Okay, order will be passed later. 2 IS, 2 IS, trials. I-27 আৰু I-32. Yes.
Item number 9.
POXO,
Yes, Lordship.
service
Service is
complete.
per order
Yes, Mr. Kosik. How much day?
37 days, Lordship.
37
7.
days. Notice, sir. Order আছে এটা, হ্যাঁ, দুটো ফাইল हुआ था। দুটো ফাইল हुआ था, order, delay confirmation, standard pay affidavit. Third, MS N. Chaudhary, learned counsel for the applicant appellant. And Mr. R. Kosik, learned additional public prosecutor for the opposite party, that's respond number 1. State of Assam, full stop. The instant application under section 160, under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 37 days, which had occurred in preferring the accompanying criminal appeal to assail a judgment and order dated. What was it? They've said 9.
Page 8.
Huh?
Page 8.
Page 8, no date or date. Where is the date?
Date of judgment 26/6/24.
Where is written?
Page 8 of the I.
Okay. Page 8 of the 26 is legal. সেইটোতো চকুত পৰিছে মোৰ। লাষ্টৰ পিনে চাই লওঁ আৰু এইটোৱে 26/6/2024 passed by the Court of Law and a special judge within bracket POXO Tinsukia in POXO case number 60 of 2023 postal by the judgment and order dated 26/6/2024, the applicant appellant has been convicted for the offense under section 6, Prevention of Children from Sexual Offences Act 2012, and he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, with default stipulation. Full stop. But we have gone through the statements and environments made in the instant application, more particularly, is it a memo of appeal or application seeking condonation of delay?
Condonation of delay.
Huh?
Page 4.
Full stop. It looks like a memorandum of appeal.
Judgment.
Where is the document regarding your engagement?
Engagement is lordship in the appeal memo,
Huh?
annexure 2 series.
Uh, it is noticed that after delivery of the judgment, an order of conviction and sentence on 26/6/2024, the Secretary, District Legal Services Authority, Tinsukia, forwarded the case papers to the Guwahati High Court Legal Services Committee on 12/7/2024. Full stop. The subsequent period, in the subsequent period, the legal aid council came to be appointed, and finally, the connected appeal, accompanying criminal appeal, and the instant application for condonation of delay came to be filed on 6/11/2024. Full stop. Mr. Kosik, it is fairly submitted. It's standard paragraph silo. As though, despite service of notice upon the opposite party, has respond number 2, none has appeared to represent the opposite party. Does respond number 2 till date. Full stop. This court is of the considered view that as a period of delay of 37 days is not significant, and the applicant has been sentenced to undergo imprisonment for life, the interest of justice would be better subserved if the accompanying criminal appeal is heard on merits by condoning the delay of 37 days. Full stop. Accordingly, full stop. The opposite party does respond number 2. In view of absence of the opposite party does respond number 2. Despite service of notice, this court is of the considered view that the further opportunity would be available to the opposite party does respond number 2 when the accompanying criminal appeal is heard on merits. Accordingly, the instant application seeking condonation delay of 37 days in as the appellant has been able to explain the period delay showing sufficient cause, the instant application on the section. Instant application seeking condonation of delay of 37 days in preparing the accompanying criminal appeal is allowed most of the office to register the accompanying criminal appeal and thereafter come out to list the case appeal for admission,
Obliged.
accordingly for admission.
Item number 10.
It is admitted to notice, yes.
Lordship, appeal was admitted.
Offense
Lordship, section 302, Lordship. And
are
30
Mr. A. Gogoi, Learned Legal Aid Counsel, and Mr. R. Kaushik, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. As per order dated 23/5/2025 of the Lower Jima Court, notice upon the respondent number 2 has been duly served. Post of none has appeared for the respondent number 2 despite service of notice. Post of para. This is the PCA received. As the trial court records are not received, ready to issue a reminder for the trial court records. Please the case out of focus.
Item 11.
Ready. Oh, after other orders matter. Yes, ma'am.
Item number 12.
There is 3011 days delay in.
Sir, we have to issue notice at this stage at least. This is bit too much.
Too much.
Heard
Vijay Sharma.
Mr. G.J. Sharma, Learned Counsel for the applicant appellant, and Mr. R. Kaushik, Learned Additional Public Prosecutor for the opposite party number 1, 3,000. The instant application under section 5 of the Limitation Act 1963 is prepared seeking continuation of delay of 3,011 days in filing the accompanying criminal appeal under section 415 within bracket 2 BNSS 2023 against a judgment and order of conviction and sentence dated 22/12/2016 passed by the legislations judge, Kamaru Metro, Guwahati, in session case number 404 within bracket K of 2012. Issue notice returnable in 4 weeks. As Mr. Kaushik, Learned Additional Public Prosecutor, has appeared and accepted notice on behalf of the opposite party number 1, State of Assam, issuance of formal notice to the state opposite party, the testimony is dispensed with the applicant. Appellant shall take steps, applicant, shall take steps for service of notice upon the respondent number, opposite party, just respondent number 2, opposite party will go by registered post AD within 3 working days.
Item number 13.
There is 23 days delay, Lordship.
How much?
23 days.
Yes, Mr. Likhe dibo 23, huh? I will dispense for you, opposite party number 2 notice at this stage. Again, likhe dibo. Huh? Over. Unknown.
Item 14.
Yes. In absence also, in absentia. We can condone?
Yes, sir.
Huh? 3 days.
3 days.
Huh? Has appeared for the applicant on call applicant, huh? Mr. R. Kosik. Maikin so can kill. Though the land counsel for the applicant is found absent on call. Comma, we are to consider view that since the period of 3 days delay is inconsequential. Wa, the sentence of by his silo, sentence of imprisonment. For the remainder of the natural life of the applicant. Interest of justice will be better subserved if the said period of 3 days of delay in preferring the accompanying criminal appeal is condoned. In order to hear the accompanying criminal appeal is hard on merits. Full stop. A notice at this stage to opposite party number so and so as sealed. Informant will be heard at the stage of considering the law. After ensuring service of notice.
Item number 15.
But here notice has to go.
Yes, sir.
A. Biswas, learned counsel for the appellant. The instant application is preferred by the applicant seeking condonation of delay of under section 5 of the limitation in 1963, seeking condonation of delay of 28 days in preferring review application. Huh?
Matrimonial.
What? You don't look at the draft. Copy paste.
There is something.
Copy paste. Obviously, in preferring the conducted accompanying appeal under section 19 of the Family Court Act to assail an order dated 4/2/2025 passed by the learned Principal Judge Family Court 1 Kamrup Metro Guwahati in Miss J case number 189 of 2018, arising out of FC Civil case number 17 of 2017, issue notice returnable in 4 weeks. The applicant shall take steps for service of notice upon the respondent opposite party sole opposite party by registered procedure within 3 hours.
Supplementary list, items 19 and 20.
My lord, can it be taken up day after tomorrow? The senior counsel has to go somewhere.
Of the education department, we have to file an affidavit in the matter of the instructions have been received. I can file it by Thursday. Can be taken up on Monday.
My lord, next Wednesday, he will not be available on Monday, so on Wednesday, my lord.
Okay.
Next Wednesday.
M. Kotogi. Heard Mr. M. Kotogi, learned counsel for the applicant, and Mr. R. Mujumdar, learned standing counsel, elementary, secondary?
The Department of School Education.
Standing counsel, Department of School Education for the opposite parties post up. As sought for by the learned counsel for the parties, leaves the case on Wednesday. This is not this Wednesday, next Wednesday.
18th.
18th.
Most.
Yes, Mr. Kotogi. Yes, Mr. Dhor. No chance.
Today may not be, time will not permit.
So you can go. We'll start with Mr. Kotogi's case. And other matters also. No chance. Other one, 18. Itu Kotogi siapa? No. We'll continue, not possible, we'll continue day to day, tomorrow at 2 again. We'll start.
Yes, sir.
Mr. Goswami, not possible. As an amicus query, you have to wait, no chance. Yes.
It's it's of occurrence of 23/8/2008, my lord. And
Junaki Gwala.
Gunaki Gwala. ma'am. Informant is Ananda Gwala. And your
Sequence, I think sequence of event
yes, my lord.
would be better understood from the IO.
I hope 21 ma'am.
Page.
Page 51. 51.
All the confusion can be removed from there.
Yes, ma'am.
That day I marked it. IO. Itu sekali compose এটা আমাদের IO.
Yes, on the page 51, you will also find. That is on 29/8/2008, I was posted as attached officer at Sonari PS. On that day at about 7 a.m., one person, namely Oren Tati of IDO Puri. Oren Tati was examined in this case, my lord. He has been examined as,
Foreign 30 examined.
yes, PW3.
Name so and so submitted an application.
Submitted an
Okay.
application stating that one female dead body was found in a drain, Mola of IDO Puri Tea Store. On receiving the application, OC Sonari PS registered a UD case hearing number 27/2008.
So
According-
meaning thereby, there was no leading
No, ma'am.
to discovery.
No one.
So Foreign 30 found it
Informed. the police.
informed.
He was a BDP secretary, yes, ma'am.
Hmm.
And then after taking the charge of investigation, I went to the place of occurrence, found the dead body in a drain, and lower part of the dead body was in a decomposed state. I conducted an inquest over a dead body in presence of executive magistrate and witnesses where I put.
When inquest was done,
Inquest was done, that is on the same day, that is on 29/8/2008.
2008. Over the executive ministry, yes,
Then inquest you will also will find at page 223, madam.
223. Okay.
Then I conducted an inquest of dead body and when I saw a tattoo mark, Sri Krishna in the right hand of the deceased. I also saw tattoo mark Sanjeev in the left hand. I forwarded dead body for postmortem examination. I drew up the sketch map of the place of occurrence. I also recorded the statement of witness.
Hey.
Then he has exhibited the inquest report P3. P6 is the sketch map of the place of occurrence in connection with so and so, so and so. Then comes the FIR part. That on 4/9/2008, one Ajar was lodged by Ananta Gwala, son of deceased Junaki Gwala.
PW,
Ananta 9. And he also submitted a photo of his mother, Junaki Gwala. On receipt of the Ajar, OC Chonari registered a case bearing number Chonari PS case number 194 under section 302/201 and entrusted me to investigate the case. I recorded a statement of informant in the police station. I seized one colored photograph of the deceased Junaki Gwala, which was submitted by the informant. I showed some photographs of the deceased to the informant, which I.
come on, minute. How after postmortem, how the cremation body, how it was disposed?
It was committed by police administration.
Police.
Yes, because
Prior to the FIR or
prior to the FIR.
prior to the FIR?
Yes.
Because FIR 49.
49.
Recovery was 29/8. UD case on the same day.
Same day.
Body was decomposed.
Decomposed.
Then
Since it was, they could not ascertain whether it was a homicidal or suicidal.
it has come on record.
Yes, postmortem has been examined.
Huh?
Doctor has been examined.
No.
Fire.
No.
Lordship.
The cremation of the dead.
Cremation that has not come.
It has come on record somewhere.
No.
Just see. One person checked out of the expired subsequently.
No. Cremation of the deceased.
Cremation or dead body, dead body.
That has not come on.
It is
that has not come.
That is not.
But anywhere.
No, they
Because,
went to.
because that is the corpus delicti,
Yeah, I understand.
right?
Yeah.
So we have to think from
Yeah, I
every
understand.
angle.
Because actually, that is
It has
informant.
come on record or not?
No, it does not come on record.
If
But-
it is not, then thereafter, what is you call, interred or exhumed.
But-
Exhumed or interred.
Exhumation is not possible in this case, my lord, because.
No, that is what. There is slight difference between interred and exhumed. What's the difference? Both are from below the earth,
Below the.
but inter and exhume are different. You slightly find out.
Yes.
If it is on the order of a court, I think it will be interred. If it is not within the order of the court, exhume. Police can exhume like that. I don't know.
Yes.
So also inter or exhume was a difference. Yes. So anybody said.
No, they went to the police station. Police station has said that the body has been disposed of. That has come because this informant. Man.
Let us read the IO.
Yes, no comment. Then I record a statement of, then comes the, on 4/9/2008, one HR was lodged by Sananta Gwala. Son of Soren. He submitted a photo of his mother. On receipt of the HR, OC Sonari registered a case number being Sonari PS case number so and so. Enterances me to investigate the case. I record a statement of informant in the police station. I seized one color photograph of the deceased Junaki Gwala, which was submitted by the informant. I showed some photographs of the deceased to the informant, which I have taken during the time of conducting the inquest over the dead body. Informant identified the deceased in the photographs as his mother. Then comes the seizure list, by which photograph of deceased was seized. And material object is the said color photograph of Junaki. I record a statement of Chittaranjan Dasgupta, where he stated he saw deceased Junaki came out from the house along with accused Sanjip Pal. He also stated prior to that Junaki told Chittaranjan that
This man was alive or not?
Page 56.
56.
I sent the dead body for postmortem examination on 29/8/2008 with the direction to preserve the dead body for 72 hours. Thereafter, I prayed before the hospital authority to dispose the dead body, and accordingly the body was disposed. Cross-examination.
So
please.
therefore, dead body could not be identified by informant, Chittaranjan Das Gupta and any other family member.
No, ma'am, yeah.
So body is gone.
Body has gone. And the cause of death
Whatever
was-
there is there in the mind. Whatever evidence is in the mind. Okay.
There is a-
Chittaranjan Das Gupta,
He's
He's no more. His 164 statement is
Died.
recorded.
a.
He died.
but that cannot be acted upon under section 32 also, Evidence Act. Because if it is relating to his death, otherwise no value perhaps.
No bill.
Yes, Mr. Kotogi?
Yes, no bill. And moreover, he has implicated only Sanjip Pal, not me, man.
Okay.
Sanjip Pal engaged other two persons.
Okay, we'll do that, we'll do that. Don't jump. Okay, then Chittaranjan, okay, I recorded the statement of Chittaranjan.
He also stated prior to the Junaki, Chittaranjan, Sanjip Pal giving her promise to marry her, committed so and so. Pregnancy of Junaki
Yes.
got aborted by Smita many times. Once again, when she became pregnant, Sanjip denied to marry her and told her to do something for her. Sanjeev also threatened her with dire consequences, not to
So
disclose that
this party is not related to the appellants.
appellant. Then comes
Not related to the appellants. So according to Chittaranjan, it was last seen kind of thing.
last into
Sanjeev,
Sanjeev.
okay.
Then comes, his statement has been exhibited, my lord. The sketch paper of the place of occurrence has been exhibited.
Place of occurrence with that drain.
No, he says, I went to the house of the deceased Junaki Gowla. I prepared a sketch paper of place of occurrence and recorded a statement of witness. The house of the complainant. He has described the house of the complainant.
That is PW9.
PW9, exhibit P9. Then, after interrogating the witnesses, I found deceased Junaki walked in the house of Sanjip Pal, and Sanjip Pal is involved in the incident. So I went to the house of Sanjip Pal, could not find him. On 5/9/2008, I got information that Sanjip Pal was present in the house. Accordingly, I went to the house of Sanjip Pal, apprehended him. I interrogated him. The statement accused Sanjipal, he stated, so this thing has come by. That is a confession statement of, that is before police not admissible. He said that he used to take money from the, he used to deny Sanjipal told one person, June Ahmed, he faced with some problem.
Who is this June Ahmed?
June Ahmed, Sahabuddin, man.
Sahabuddin
Sahabuddin.
told one person initially he faced something.
And he faced with one problem, Sanjipal so and so for promising to marry
Sahabuddin,
Sahabuddin.
one problem.
That asked for solution from June Ahmed, told Sanjip that he had the matter from others, and suggested that if he wants to solve the matter, he needs to kill Junaki.
June Ahmed.
So they need to help of another boy from Rajpukuri. June Ahmed, on 23/8/2008, June Ahmed alias Sahabuddin, Rekibuddin, reside of Radhapukuri and Sanjipal together had a vehicle from one IT Ahmed, went to Kukubil near a bridge and they made Junaki. As they could not there, as she was told before to go there by principal, Sanjipal Rekibuddin took Junaki towards Chapagat Tea Estate and June Ahmed Sahabuddin followed them by riding a scooter, namely Vespa.
This is based on Sanjeev's statement.
Statement, man.
Sanjeev's statement.
Yes, ma'am. Then,
And after arrest.
after he was detained.
So this will not be admissible.
That is not made.
And no discovery.
No discovery.
Hmm.
He says that one plastic rope was seized by accused. So,
There is the discovery.
that was a discovery, but that was earlier also it was found.
Huh?
Earlier in the seizure list also it was there. So,
Is it there?
yes.
When they reach Sanjeev tie. Oh, that is also statement.
Statement.
When they reach Zoboka, so and so, Sanjeev tied a plastic
Yes.
rope in the neck of Junaki, another person, June Ahmed. Okay, this is the version of Sanjeev.
Sanjeev.
Pull the rope. Therefore, they threw the plastic rope in the Zoboka. After that, they took the dead body. So this entire statement is attributed to Sanjeev.
Sanjeev.
Awadhi, he said, I seized the plastic rope which was sold by accused Sanjeev.
Sanjeev, yes.
Huh.
That is the plastic which was sold by accused Sanjeev.
You said that it was seized already?
It was seized, yes. Yeah, it was page 219, man.
219.
19, man.
219.
It just is a list, man.
Which date? 6/9.
6, man.
8 AM.
Yes, man. Because they are witnesses
on being laid. Sanjeev.
But PW3 and PW10 says otherwise, man.
They are seizure witness.
Seizure witness.
Foreign, okay.
Oren Tati and Montu Gugol.
Okay,
He
well-
stated it was lying earlier of the government.
Lying earlier.
Yeah. If you take up PW3, my lord.
So double seizure. Okay. Hmm. 6/9. Page 55.
That comes, my lord. Then he, on 6/9, along with Sanjipal, went to the South so and so. Then he sees one scooter, Vespa, my lord.
No, on 6/9.
6/9, my lord, I, along with accused Sanjipal, went search of June, Sahabuni Ahmed's house, but could not find him. Again at 2 PM, I went to search Bhaiti Ahmed Ekimudi to his house. On finding him in his house, I apprehended him, brought to the police station. On 6/9/2008, I communicated with Simoliguri police
So
station.
you were arrested on 6/9.
6/9,
That's Bhaiti Ahmed, Rakibuddin.
Ekimudi,
His appellant number?
2 million. Then on 6/9, I communicated with Simoliguri police station. Simoliguri apprehended June Sahabuddin, we handed over to us. We took June Sahabuddin in our custody. Then I see
Both on 6/9.
6/9.
6/9.
Then I seized the scooter Vespa along with relevant documents from the scooter as shown by Sahabuddin, which was used at the time of incident.
1 minute. এটা কি নিবি? Legally অলপ difference আছে। Anyway. Legal differences. Legal believe. কেন হয়? হ্যাঁ? হয় exhume আর disinter হবে। Disinter. Inter. Disinter হবে। Inter, disinter. ঠিক আছে, most probably happen দুনিয়ায়। Yes.
Then he says that I seized the vehicle Tata is along with the relevant documents from Mr. Tultul Borua, which was used at the time of incident. That Tultul Borua was also examined by the.
He is PW.
Below 16. Page 3940. He was, then the PW P3 is a Caesar list, where his Tata AC one number so and so was seized by police. Exhibit P4 is Caesar list with documents of Tata Torrijos. On finding sufficient materials, accused person, I arrested the accused person and forwarded to the court. Exhibit P12 is the arrest and forwarding report of Sanjeev Pal. And P13 is the arrest memo of accused Ekibuddin Ahmed alias Bhaiti.
Dated.
Dates, date, that. P12, my lord, that is arrest memo of Ekibuddin, my lord. That 251, that is on the 6-9, my lord. 6-9-2008.
6-9.
Exhibit P13.
2008. Okay.
And so far as forwarding of Sanjeev Pal is, my lord, that is page P12, page 249.
Date,
my lord. Here it is, my lord, 6-9.
same date.
Same day. Then comes arrest memo of Sahabuddin, June.
Same date.
Same date, my lord. 6-9, that is exhibit P14, page 253.
Where is the FSL?
FSL. Then comes exhibit P16 is the FSL report, my lord.
Page.
Page 258. No poison was found.
No poison.
No poison.
In the viscera.
Viscera as well.
Like liver, kidney,
Liver, kidney.
stomach,
And
and its contents. Okay. So then
PW 16 is the 17 is the chassis.
Postmortem.
Postmortem, my lord, that is
Page.
It was the doctor was examined, my lord.
Postmortem examination.
PW 19, my lord.
Report.
230.
Exhibit.
250.
P5. Page.
230 to 34. It starts from 230.
Decomposed female body full of maggots. No sculpting case of neighbor neck injury. Teacher absent from school. Teachers absent.
The cause of death could not be established.
Skull bone facial features of my lords teeth from both jaws, features absent, which are preserved in one body, kidney and other murder bottle could not be ascertained.
Ascertained.
Viscera, no poison.
No problem.
Okay, so it is not ascertained
Whether it is homicide or suicide.
homicidal, suicidal, or accidental,
Accident.
or natural. Okay, so this is the investigation. Okay, next page.
Next page, my lord, the PW 21, the examination is complete, my lord.
No, page 56. No, postmortem. After 6 days,
Let
dead
us
body Azar was lost. That is on perhaps 4/9. Dead body was not identified.
Right, right.
Accused confess their guilt before me. Section 25.
25.
I have not made any prayer for confession of extrajudicial confession, for confession, or extrajudicial confession statement. I prepared one's case map in UD. I prepared the other is given after lodging a This is a plastic rope. Okay. When I see the plastic rope, that disease, then the PW, Horentati, PW 3, Montu Gogoe.
We're present. The witnesses.
Witness were present. Okay, let us see Montu.
Montu, my lord, and that is PW 3.
But it is not a fact that I did not take. Okay. I did follow the crime scene. I see the Vespa. Patayas, postmortem, which occurred in the dead body was mentioned as unidentified. Let us see the postmortem once again.
Yes, my lord.
Two.
Postmortem is, my lord. 230. 230.
So it was never identified.
No, my lord.
Unknown. Okay. Then PW 3 and 10.
The PW 3, my lord, he is the.
Now let us have from 1 to.
1, yes, sir. That is nice.
From 1 onwards.
PW 1 is, my lord, Mosomi Chatterjee. Mosomi Chakraborty.
Mochumi.
Mosomi. He doesn't know about the incident. Police came to our house. I know Junaki Gwala was murdered from which police came. I do not know about the incident.
PW 2.
Minty Das, my lord, he's a Asa worker, my lord. Junaki died. I know about the accused person. Police asked me about Nal Sandeep. That much only. He really went, my lord. PW 3, my lord.
Yes, Caesar.
Caesar, but it doesn't say about the Caesar. He gave the earlier information, my lord. I do not know the accused. I know accused Akibuddin Ahmed. I do not know others. The incident occurred 4 or 5 years ago. One dead body was kept on a drain at our tea estate. It was a female person. People informed me. I was a BDB secretary. I informed the police. Later on, police came. The dead body was of a female from Sunari. Police told me it was kept after his murder. I heard the accused person's completed murder. Later on, the accused persons were arrested. I have not seen the dead body from near. I know the accused Akibuddin. I do not know about the incident. I do not know personally about the incident. Only heard about the incident. That dead body was not seen from nearby me. I do not know whose dead body. So this Caesar was not shown to him at that point of time.
Caesar list was not shown to him.
Yeah. Then comes PW4, Sumanto Das, a tailor. I do not know the informant, but know the accused. I do not know about the absent accused person. 7 or 8 years ago, incident occurred. I heard accused along with 2 others committed the murder at dead body was of Junaki. I heard. I do not have any person. So he also hears it. Then comes PW5, Prem Newa. He's a businessman. He says that I know the informant also Sahabuddin and Sanjeev. I do not know the other one. I know Junaki Gwala. 11 years ago, the incident occurred. I know Junaki worked at Sanjeev home. Sanjeev was a teacher. Sanjeev had a relationship. I heard that Sanjeev had a relationship with Junaki. Sanjeev, house of Sanjeev is half a kilometer from my house. I have not seen Junaki for a while. I heard later a dead body of Junaki was placed out at Kalvat at Idapur Estate. I heard that accused persons killed Junaki. Out of the accused person, I do not recognize him. Police arrested 3 persons. Police interrogated me. I am not going to see the dead body. My house is adjacent to the house of Junaki. Son of Junaki is 10, 12 years old. I do not remember for whom I heard Sanjeev was a relationship. I did not ask Sanjeev about the matter. I do not have any personal knowledge about the incident. I have not seen the accused whom do not recognize. Other 2 accused whom recognize. I saw him in the town. I have not seen them in the police station. I did not went to the police station, place of occurrence. I came to know about the incident when I saw the news feed. So that is also yes, man. Then comes PW6 between the task.
TV audience.
Eh?
TV audience.
TV audience. He's a reporter. This next witness PW6.
Okay, journalist.
He is I know the informant and accused person present in the court. I know the absent and accused persons. I do not know the Dunali incident occurred in 2008. I am a reporter of newspaper Doinik Janamuni. I received the news of the incident and I went to the police station. I heard the OC interrogated the accused persons. I heard the accused persons confess the guilt. The Junali worked as domestic help in the house of Sanjeev Pal. I heard the accused persons confess that they had killed Junaki and kept her dead body at Ida Pukuri. Police asked the matter, accused persons were arrested. So he was present at the time when confession was recorded by the police. I went to police station, nothing more than that. Then comes PW7 man, Narayan Day. He was I know the informant, present accused, as he was a court commissioner. I could not recognize others if I see them. Then he says that, but I know Sanjeev Pal, do not know the other accused person. The incident occurred in 2008. So he also was a reporter at that time. Yeah, I was working as a reporter of Amara Home. After receiving the news that accused Sanjeev was involved in a murder case and arrested police, I went to the police station. Found Sanjeev confessed and he murdered Junaki, who used to work at house. Then I heard that they had a relationship. The dead body was found in one grade and Ida Bukuri. The state police did not ask me anything. The day of the police station, I did not talk to Sanjeev. I was only from the police station. Police I have came to know incident. I do not know since the deceased was absenting missing. I found interrogation was going on. When I went, I do not remember how much police was with the accused. I do not know if confession was made out of fear of police. That much, man. Then PW8. PW8, my lord, is Onit Kulmi. I do not know Ananta Gwala. I do not know the deceased Junaki. I do not know the accused standing in the dock. About 5 years ago, 5-6 years back, one day at Chopoka Bagam Paddy Field, I was busy in fishing on a pond. Police personnel came and asked me whether I know the murder had committed. Then I replied, I know nothing about the murder. I know nothing. Why they have called me to adduce evidence. PW8. PW9, Ananta Gwala. That is the
Son, informant.
informant. I am the informant. Junaki Gwala was my mother. I know all the accused persons. Incident took place in the year 2008. At that time, incident, my mother walked in the house of Sanjeev Pal. I heard from the people that my mother had an affair with Sanjeev Pal. Sanjeev Pal used to take my mother with him whenever he went outside. On one day, Sanjeev Pal took my mother to Guwahati along with him. But as my mother did not return home, even after one day, I went to the house of Sanjeev Pal searching for my mother. Sanjeev Pal told me that he had not taken my mother anywhere with him. Later on, a person by name Niranjan Das said to me that my mother had told him that Sanjeev Pal had threatened her with death. And Niranjan is no more. As I failed to trace my mother, I lodged a Ajahar with the police station. 3 days after lodging of the Ajahar, my mother's death
Niranjan also expired.
expired. I failed to trace my mother. I lodged
And what, who else? Chittaranjan. Chittaranjan also expired.
as expired.
Same, I think, same person.
Same person.
Same person.
Same person.
Same.
Same.
Okay. Niranjan, Chittaranjan.
Then my maternal uncle, as I failed to trace my mother, I lodged an Ajahar with the police station. 3 days after lodging of this, my mother's dead body was found near the culvert.
This is wrong.
Wrong. It's wrong. It's only before.
Before, because 29/8 perhaps.
Yes, ma'am.
Huh?
Yeah, and he lodged the FIR on
29/8 body was found,
Yes, ma'am.
is it not?
Yes, sir.
29 ED case. Subhan Gola identified the dead body. This is also wrong then.
Yes,
Huh?
yes, yes.
If the dead body was on 29/8/2008,
Yes,
then thereafter,
5 days, ma'am.
inquest was on that day.
Inquest was also on.
Then postmortem on, postmortem on,
Postponed.
postmortem,
Postmortem was done on my lord. Yes.
postmortem,
239.
date, 29/8, 29/8,
29.
29/8. About the identifiable. He said, I could not see my mother's dead body.
Yes, he could not see the dead body.
Maternal uncle Subhan Gwala.
One
Was he a
identified the dead
witness?
body.
Was he a witness?
Subhan Gwala, my lord. One. Subha- Yes, yes, he has been examined.
PW 20.
20. At the time, I was a student of class. My mother had died before the incident. My father had died before the incident, which so and so is Ajar. Then I lost the Ajar for recovery of the dead body. My mother had gone to Guwahati for 4 days before her dead body was recovered. My mother and I were only members of him. I informed my maternal uncle, maternal grandmother, Uti Gwala, that my mother had gone missing. My mother told me that she was going to Guwahati with Sanjeev Pal. It is not a fact that this statement is true, and this thing is not mentioned in the Ajar which I lost. I was about 12 years by the time of incident. I lost the Ajar on being advised by Niranjan Das. Now I came to know that Sanjeev Pal had killed my mother. It is mentioned in the Ajar, I suspected Sanjeev to have killed my mother. Then comes PW 10, Mintu Google. He says
Into that Caesar.
Caesar. I saw I don't know, I saw a gathering beside a drain. I went there, I saw a dead body of a woman lying there. Dead body was not in a condition to be identified. I saw a pair of sandals lying beside the dead body. Police found a plastic rope. So it was there earlier. Of that. So leading of discovery is not actually it was found along with the dead body. The police found a plastic. While the police seized the pair of sandals, they took my signature in the Caesar list. Exhibit P2, P10 is the Caesar list. P2, P1. My signature was obtained when the inquest was prepared. P3 is the inquest report. Exhibit 3 so and so.
Where is the Caesar list? P2.
P2, you'll also find. P2 is P2.
19.
P2 219.
219.
Plastic.
Because your lordship, one thing is very important, madam. Because he says, madam, this witness says, he saw the dead body of a woman lying there along with the plastic. Now,
Dead body was lying there.
yes, along with the plastic.
So I gathering and beside a train,
Yes,
a drain.
rain.
Then I went there, saw the dead body of a woman lying there. Right. The
So-
dead body was not in a condition to be identified.
Yes,
I saw a pair of sandals lying beside the dead body.
yes,
The police found a plastic rope.
yes.
While the police seized the sandal. Sandal. Oh, where is the sandal Caesar list?
Caesar list, my lord, your lordship is Caesar list C. Your lordship can
And the sandal Caesar list?
Central Caesar is not, it is plastic rope Caesar list.
No. Any sandal was seized.
No, man.
So it will not cease.
No, it's not sealed. But if your lordship go by the seizure list, my lord,
Huh.
it refers to Sonari PS case number 194 of 2008, man. Because at that time, FIR was not lost, man. It connects on the UT case, he ought to have been seized, man.
But he said date of seizure is 6/9. After FIR was on 4/9.
4/9. But dead body was found at prior to death, my lord. Because rope was found along with the dead body.
Huh.
So his signature was obtained, my lord, in a
Maybe saved for the later.
later. Which means, my lord, his witness statement is otherwise, my lord.
Saved for the later.
If you lordship goes by the statement of the witness, my lord, naturally, it would be prior to lodging of the FIR, it ought to be registered as UD case, my lord.
Hmm.
But now he says that this Caesar list says about this recovery part also, circumstance of the Caesar, plastic rope.
And he was an inquest witness.
Inquest witness.
29/8.
29.
Inquest witness. And he said, later I came to know that the accused had been arrested. Meaning that he did not accompany. IO said, this man accompanied. And the plastic rope was seized.
Yes. And inquest is on 29/8, my lord. And both the signatures were approved, my lord. That is the signature of Mintu.
Things are not matching. Okay.
And he says, my signature on inquest was, I came to know the accused has been arrested. Police were present there. When I went to the place of offense, I do not know where the police has brought the rope from. Then comes Ankit Kurmi, PW11.
Ankit Kurmi. He is like the same man, perhaps.
No, nothing.
No. That man.
Then PW
24, page 24.
Page 24. 24 is Oren Kurmi.
No, 24 is Ankit Kurmi, page 24, PW8.
PW8 is Ankit Kurmi.
And PW11?
PW11 is
very important witness, examined twice. Son of Hori Kurmi. Joboka.
He was ambulance driver.
In 2021.
Yes, again
he was 34 years. In 2022, he was 23. 23.
Two occasions he has been
36. Very important witness.
Twice has been examined.
Huh? Twice he has been examined. And he said on both the occasions, I don't know.
Then comes Rafiq Ahmed. He also from the reporter of Newsline. I do not know the informant. I know the accused person. Incident took place so and so. I was working as a reporter and around I received information from police. A woman has been murdered. On receiving news, I went to the Sonali police station, arrived and saw the police. Brought 3 persons apprehending them. In a police station that said 3 persons stated they had caused the murder, so the dead body in his brain and either put
Madam?
Nothing.
He said police took us to Ido. He says, I saw police had brought 3 persons after apprehending them. In the police station, said 3 persons stated they had caused the murder and thrown the dead body into a drain of Ido Tea Estate. Then he said, police took us to Ido where the accused person shown us the dead body in the drain. Accused person shown. Dead body was discovered much as, before the arrest of the accused person. This journalist.
As regards that Sanjeev Paul, motive was maybe the factor.
We will not make much comment on Sanjeev Paul. Maybe his appeal may be lying somewhere. We don't know. So we will not say much observation about Sanjeev.
As regards other 2 accused person, only that leading to discovery, that is not like before the procedure. Nothing.
We'll resume it tomorrow at 2. Anything further?
Nothing,
Other
my
than
lord,
this?
except the confession before police, my lord. Please. No evidence actually.
That your linking is on the basis of Sanjay Paul's statement.
Statement, yes. That to
And Sanjay Paul's statement is also
before police.
police after apprehension.
Yes.
Arrest may be same date, but initially
He was
Sanjay was taken into custody. And on the basis of his statement, you two were taken into custody.
Yes.
And arrested on the same date and produced before the court on the same date.
Yes.
But that statement is hit by section 25,
Yes.
26.
So
both.
there is no evidence, there is no evidence as such, my lord,
And so
implicating state.
discovery is also not there because already the body was discovered,
Along with the rope also.
rope, sandal, whatever, in a drain. Postmortem was done, inquest was done, reason for death was not known. Poisoning was ruled out. So this is the secret.
The case of no evidence actually. So basically the case of no evidence. Not to say.
How they have been convicted?
On
We are also interested to find out.
that circumstances as you described in the judgment.
It is interesting to find out.
Yes. That you will also find.
Very good. Judgment.
Chain of circumstances, page 207. Nicely elaborated.
No. Say page 2, paragraph 40, man.
Paragraph
40, man.
page.
Page 207. Judgment part, man. Paragraph 40. Number one, Junaki Gola used to work in the house of accused so. There was a love affair between Junaki and accused. A number one. A1 used to have sex with Junaki and with the promise to marry. Junaki got pregnant. A1 used to get pregnant, aborted. There's from PW1, 21 man. The Lordship may kindly see. He gets given the regarding pregnancy part is PW IO statement. Junaki passes the urge A1 to marry her. AU refused to marry her, PW21. Junaki used to take advantage of extracting money from A1. Illicit love affair with Junaki became public, PW9, 21, 28. A1 caused abortion Junaki, PW9 and PW21. Then comes our part, madam. Number 9 circumstance. A1 disclosed the matter with A2, that is PW21. A2 advised A1 to kill Junaki, also take the help of another boy, A3, PW21. A2 hired a Tata Ace vehicle. Junaki Gola A1, A3 went by Tata vehicle, 123 to by PW21. A2 followed Tata by riding a Vespa scooter. P11, Junaki was killed by a rope at Dopoka Tea Estate by all accused persons. Exhibit P2, P10. All accused persons took the dead body, threw into Nala. Exhibit P4, dead body was recovered from identification. The PW3, PW20. Dead body of Junaki was identified. PW9, 20, 21, and Chittaranjan Dasgupta, Exhibit P.
Chain is complete. Sarada Bidisan fulfilled.
So although star witness is PW21, these are everything.
Chain is complete. Question is, chain is complete on the basis of admissible evidence or inadmissible evidence? Chain is complete.